The preamble to an act sets out the main objectives which the legislation is intended to achieve. It is a sort of introduction to the statute and many, at times very helpful to understand the policy and legislative intent. It expresses what we had thought or dreamed for so long. The Constitution makers gave to the preamble the place of pride. It embodies in a solemn form all the ideals and aspirations for which the country had struggled during the British regime. In Re Berubari case, the Supreme Court had said that the preamble to the Constitution is a key to open the mind of the makers and shows the general purpose for which they made the several provisions in the Constitution. The preamble declares, "We the people of India having solemnly resolved constitute India into a sovereign socialist secular democratic republic and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and to opportunity and to promote among them all fraternity, assuring the dignity of the individual and the unity and the integrity of the nation." In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact and give to otherwise ourselves this Constitution. Preamble. How far useful in interpreting the Constitution? The preamble is the key to open the mind of the makers, but it does not mean that the preamble can override the expresses provisions of the Act. In case of the Supreme Court held that the preamble was not a part of the Constitution and therefore it could never be regarded as a source of any substantive powers. Such powers are expressly granted in the body of Constitution. What is true about the powers is equally true about the prohibitions. It has limited application and can be resorted to where there is any ambiguity in the statute. If the terms used in the Constitution are ambiguous or capable of two meanings in the interpreting them, some assistance may be taken from the objectives inherent in the Constitution and the construction which fits the preamble may be preferred. But in Keshavanand Bharati's case, the Supreme Court rejected the above view and held that the preamble is the part of the Constitution, though in any ordinary statute not much importance is attached to the preamble. All importance has to be attached to the